Good afternoon, everybody. My name is Mike Fiffick. I am the managing member at Fiffick Law Group. I'll be your presenter today. Thanks so much for joining us for Hope for the Best, Plan for the Worst, estate and trust planning for families that have children with special needs. So it's my pleasure to be presenting this to you. My law firm is Fiffick Law Group. We have offices in Pittsburgh, Allison Park, which is a suburb of Pittsburgh, and then we're in the Philadelphia suburbs as well in Radnor, Pennsylvania. And the information that I'm going to share with you today is general information, I think, that pertains to estate planning and trust planning for children with special needs. So I think this is going to be applicable to you generally, no matter where you're dialing in from. But if you have questions along the way as we go through the presentation, by all means, drop them in the Q&A, drop them in the chat, and I will try to address your questions at some point during the presentation. So with that, why don't we go ahead and move forward? And here's what we're talking about. Families that have children with special needs. There are over 3 million children in the United States had a disability as of 2019, and that's really a sizable chunk of the population under age 18. And that number has been increasing over time. And the most common disability type amongst children with special needs is cognitive difficulties. And that's really jumped in prevalence, perhaps due to more advances in diagnostic studies to inform families whenever their children have particular disabilities. So that's what we're talking about. There are a lot of families that have this situation, whether they're children who are under age 18, or maybe you're caring for a child who is an adult. We're going to be talking about all of those things today. So here's what we're going to cover today. The benefits of planning for families that have children with special needs, whether they're minors under age 18 or whether they're adults. We'll talk a little bit about guardianship and comparing it to a power of attorney. We'll talk about planning for living arrangements for your child with special needs. We're going to talk a little bit about public benefits that are available for the special needs population. That's important to understand, in particular, as it relates to your own estate plan and what assets you are going to leave to care for your special needs children after you're gone. It's important to understand how that can impact their ability to continue to receive these government types of benefits. And then we'll talk about some estate planning strategies that you might want to consider for your family. So there are lots of benefits for advanced planning for your child with special needs. It'll provide financial security. It can help you leverage means-tested public benefits, meaning you want to still take advantage of those while also having your hard-earned assets be available to enhance the enjoyment that your child has in life. You can select proper team to provide for lifetime management of your child, plan for appropriate housing, such a difficult thing to be thinking about as a parent. You can provide an ongoing system of advocacy. You know, parents so often, their biggest role is to serve as advocates for their children with special needs. Plan for caregiving needs, coordinate entire extended family planning. It really is an all-encompassing whole family planning type of an effort here. And we can also protect your child from predators that are out there who want to maybe take their assets. And then we can preserve assets for other heirs as well. So there's really a lot of reasons why it's just so vitally important for you to be engaging in some planning. So let's talk first about guardianship. This is a term, might also hear it called conservatorship. Guardianship, conservatorship are relatively synonymous terms. We're talking about the same thing. So really one important decision faced by parents of children with disabilities is a transition into adulthood, because you no longer necessarily can have the authority legally to make decisions for your child that you do whenever they're a minor. That kind of changes as you get older. If parents want to be involved, need to be involved in financial or medical decision-making, managing assets for an adult child, then either a power of attorney or a guardianship may be appropriate, depending on your child's cognitive and mental capacity to understand those things. Ideally, if your child can understand the power of attorney document, and they don't need to understand it like a lawyer understands it, they need to have a basic understanding of what they're doing, that they have control of their assets, and that they are giving someone else some authority or the same authority to control those assets, just like your child does. That basic understanding may very well be enough in order to make a power of attorney appropriate for your child to complete. And it's really preferable as opposed to a guardianship proceeding. So this is really the ideal choice for a child entering into adulthood to consider a financial power of attorney so that you can assist them with their finances, have access to their accounts, be able to talk to a bank or some other type of financial advisor. But they also want to have a healthcare power of attorney for them as well. The law does provide some limited pecking order of who can make medical decisions for certain family members. But in the event of parents who might be in conflict, it really is just a good idea to have a document that specifies who has authority, how they can be contacted, all of those very practical things that are needed to care for a child, especially in the time of crisis. Might want to have some type of a HIPAA authorization for more than just one family member to be able to have access to medical information for that child, because sometimes it takes a village, right, to care for somebody, and more than one person needs to have access to that information. Now, if your child is not able to make their own decisions as an adult, really the parents should be thinking about acting before their child reaches age 18, right, to get this plan in place. Because the law will presume once your child turns 18, if there's nothing in place like a guardianship or a power of attorney, that they have the mental capacity to make their own choices. So very important to be thinking about getting this authoritative process in place, these authorizations in place. When a power of attorney is not appropriate, then guardianship might be something else to think about. And guardianship refers to a court-administered process of placing somebody in charge, or stepping in the shoes of somebody else to control their finances or assist them with their finances, also to help them make medical decisions. So a guardianship is a court process. It involves filing some type of a legal document, a petition or a motion or some other legal document, asking the court to consider whether the circumstances are appropriate for a guardian to be appointed. And if the circumstances are appropriate, who can serve as the guardian? And it's not always the parents who can do that. Really, you're giving that decision-making power up to the court. So the court, a judge that you don't know, is going to be making decisions not only whether your child is in need of a guardianship, and sometimes that might be in question. And this petition is going to be read to the child. It has to be on a mandatory basis. The child may or may not have the ability to retain counsel or to be involved in the process, to go to court, to object to the process. So those can all be very traumatic type of things to happen. Just to have all of this stuff read to the child and go through this process can be very confusing, very upsetting. But the court is going to make a decision whether a guardianship is appropriate, and then also make value judgments on who should be the guardian. And so not only is the child in the spotlight, but you're in the spotlight as well, or whoever the guardian is intended to be is going to be in the spotlight to determine their fitness for serving as a guardian. And then you also have the whole question of whether you're capable of serving in the role of guardian, because that will be a court supervised process. As a guardian, you will very likely be required to file reports with the court on an annual basis of what you've done to manage your child's assets. And so there's a burden that's going to come along with that. And you will always be subject to court scrutiny. The court will look at those reports and may contact you to ask questions about it. So if you're not a good record keeper for yourself, you're going to have to become a good record keeper if you're going to put yourself in the position of being a guardian for your child. It could be a guardian that has complete authority over the child's finances, where the child has no authority over their own finances. That's all been placed with the parent. Or it can be limited, where there's some sharing of that obligation between the parent and the child. Guardianship typically is going to take several months to work its way through the court system. And there's going to be an expense involved as well if you want to retain counsel to assist in that process. It may also require testimony or medical reports from physicians or other medical experts to establish that the child has a disability that necessitates or warrants the imposition of a guardianship over their assets in their decision-making authority. And oftentimes, obtaining those medical reports or even testimony from a physician costs money as well. So if you are entering into a guardianship process, you really should be prepared to spend several $1,000s from the beginning all the way till the end of that process, and it'll take several months along the way. If it can be avoided, really, that's the best situation entirely. So another thing that you should really be thinking about are planning for living arrangements. And this is a basic but difficult decision for children with family needs. None of us likes to think about when we aren't going to be around anymore, right? It's not on our to-do list. It's not a pleasant thing to be thinking about. But if you're a parent of a child with special needs, it's particularly urgent. And sometimes parents have a tendency to really delay this planning process until they're older, right? Or until some type of a sudden health event comes into their own lives that really makes this a priority type of a situation. Of course, crisis planning is always the most traumatic, upsetting, and perhaps worst time to do any type of planning. So it's really something that you have to be thinking about much earlier than when it is basically faced upon you. To what's going to happen to your child whenever you're not around anymore, or whenever you are unable to care for them because you yourself have some type of a life event that's occurred, or a sudden health problem, or whatever that's going to impair your ability to care for your child. I've had clients who have cared for a disabled child well into their advanced years, into their 70s or 80s. And only when mom or dad can't take care of themselves anymore do they confront this question of what's going to happen to my child when we both basically have to move out of the house. Or folks who have not really have a plan because they're the caregiver, that's what their lives are devoted to, but then they have a sudden health event that necessitates surgery, perhaps a period of convalescence or rehabilitation, even in a facility, and then they have to sort of scramble to figure out what those plans are for their adult child. So we all know that's really something that we should be thinking about. We know that, just encouraging you to make it a priority to really start investigating what those alternatives would be, whether they're living in a home. Maybe it's appropriate for your child to live in a home with a caregiver of some kind, what the options are that are available, what type of care is appropriate, how much it costs, or the types of facilities that are around that might be appropriate for your child. Much easier to perhaps transition them into those facilities when they're a little bit younger rather than older, and figure out how that's going to be paid for as well. So these are really big decisions that families should be thinking about relatively early on. If it's appropriate for your child to continue living in your home, and I think many people would consider that to perhaps be an ideal situation, this decision-making process may entail making changes to your home that are consistent with your child's particular disabilities. Maybe placing your home into a trust of some kind that you have put money into to pay for the bills to maintain the home after you're gone or not able to live there yourself anymore, so that it benefits your child. Those are some options that you might have available to you. So let's switch gears now, and we're going to talk about protecting the eligibility that your child has for public benefits. So there are a variety of benefits, and if you have a child that's collecting these, then you're probably familiar with these. But we have basically 3 different categories of benefits that are important to categorize them for purposes of this conversation. First and foremost are needs-based public benefits. So you can't get them unless you pass some type of a qualification based upon need. Supplemental security income, SSI, Medicaid, expanded Medicare are examples of those types of benefits. We have entitlement benefits as well. Social Security, disability, Medicare. These are things that if you qualify, you're going to be getting them as an entitlement, maybe perhaps just based on age. And then we have other benefits programs as well that are out there. And there are a variety of them. They're going to vary from state to state. But these are the basic general categories. So let's talk a little bit about SSI. So SSI provides a monthly cash grant for food, shelter to a disabled child or to the aged 65 or over. And here are a couple of stats. I think that these are 2023 numbers. I didn't correct that in 2022, but these are the Pennsylvania figures. The maximum payment in Pennsylvania for 2023 is $914 for an individual. If that qualified person is living with their family, right, in the home, then they're going to get less because they need less. They don't have to support themselves to pay rent and those types of things. And then some states might pay a supplement to folks who qualify for SSI. Pennsylvania does. Some states do not. Usually if it's a supplement, it's a relatively small amount. In order to receive SSI, the person must meet 2 primary eligibility goals or tests. First, they have to be medically disabled. So they have a physical or a mental disability under the statute for supplemental security income, SSI, or they have to be elderly, age 65 or older. In addition to satisfying the medical disability component, they also have to have income or resources, meaning assets in their own name that are below a certain amount. That's the resource test. So it's measured one time each month. So it's not a snapshot one time in their lives that if you qualify once, you qualify forever. This is actually a rolling, ongoing test that you constantly have to comply with in order to continue receiving SSI. That's why it's important for our conversation, because if you pass away and you leave assets to your disabled family member, right, in their own name, that in fact may cause them in the month that they receive that money to not meet the resource test. And then there's going to be a disruption in their ability to collect that money. And we're going to talk a little bit more about how that works later. They also have to comply with an income test. So the income that they receive in any particular month has to be below a certain figure. So these are the basic eligibility requirements. So for purposes of the resource test, meaning the assets that somebody owns in their own name, there are different types of assets, some that count for purposes of eligibility and some that are disregarded or don't count for purposes of eligibility. So the basic figure is $2,000 for an eligible individual. That $2,000 could be $2,000 in a bank account, a checking account of some kind. If they have $2,800 in the checking account, then they don't meet the resource test. If it's a couple that's applying, the number is slightly larger. And again, this is measured on a month-to-month basis. So if the only asset that the person owns is a checking account, if that checking account goes above the $2,000 in a month, that may disqualify them for some period of time until that money is spent down below the resource amount. So again, if you are leaving assets to a child with special needs, and you may cause them to fail to meet the resource test and thus disrupt their collection of benefits going forward. That's how we're connecting that with the estate planning. That's why it's so important to be careful about that. So assets that don't count for purposes of eligibility, a principal residence or an automobile. So they can own these things and the government just disregards the value of those assets for purposes of determining whether they are eligible. So other assets that aren't going to count, household items like a toaster, their clothes, personal effects, things of that nature. Of course, unless they have Chippendale furniture or unless they own the crown jewels, right? Those are going to be an issue. Maybe perhaps musical instruments, unless they're storing a Stradivarius somewhere in the house. Burial insurance up to a certain value. Irrevocable burial trusts or burial funds, you can prepay those with a funeral home. There may be insurance companies that will sell you a special burial insurance policy, and every state allows you to have a policy or burial insurance or some type of a prepaid burial plan. There's going to be a value limit that you can have, and it varies from state to state, before the amount of that in that account is above the limit for purposes of counting it for eligibility. Burial plots, vaults, those won't count. And then life insurance policies with relatively little cash value. These are all assets that also don't count for purposes of eligibility and aren't going to cause a problem for you. So we also have an income test, and there are different types of income that can impact someone's continued eligibility to receive SSI. One type of income is unearned income. So this is gifts, meaning a gift from an estate or a cash gift that Aunt Betty would give somebody. Payments from annuities, pensions, support payments. This is all unearned income, meaning it's not W-2 earnings like from a job, right? So this is money that you get from other sources. The unearned income reduces benefits that the SSI recipient receives dollar for dollar after the first $20 per month of unearned income. Earned income consists of wages. So if the disabled person is working, that could potentially impact the amount of SSI that they would get. And this reduces the benefits dollar for dollar earned after the first 65 earned on a monthly basis. So there's a little bit bigger of a cushion available for these benefits. Another type of income, we call it income, although it might not seem like it is what's called in-kind support and maintenance. This is like a gift, not of cash, but of something. Maybe you give somebody food or clothing. Perhaps you pay bills on their behalf, but you don't give the person the money, right? These are in-kind things that support and maintain that person. These also reduce benefits dollar for dollar up to a maximum of 1/3 of the benefits. So this doesn't have as big of an impact or as direct of an impact, but it definitely can impact that. So if you want to pay for an apartment and all the utilities for your disabled child, even though they're not receiving any money, that's an in-kind gift that is reportable and can reduce the amount of their SSI benefits on a monthly basis. And then there is deemed income. So if they're living in a household with somebody who earns income and they are benefiting from that, that can also have an impact on their SSI benefits as well. So lots of different ways that the government wants to try to limit eligibility if you are earning an income. So again, SSI exempt income and earned income, the first 20 of any income is exempt, plus the 65 of the first 20 of any unearned income, right? Gifts is exempt, plus the first 65 of any earned income, meaning W-2 earnings from a job. So here's a little example of how that might work, right? So $585 was earned in a month. The SSI check will be reduced by $250, and there's a little calculation there. 585 less the $85 of total income combined exemptions would reduce the amount of the benefit. That is a very simplistic explanation of how that works. Let's see here. Go through that. It's a little. Let's talk a little bit about in-kind support and maintenance, the types of things that you could give to a disabled person that could potentially impact, because there are some things that count, some things that don't count, right? Food, if you're paying their mortgage, if they're paying their real estate taxes, rent, heating, fuel, gas, these types of things, these are going to count for purposes of income reduction, right? These are going to be taken into consideration and can reduce the monthly benefit that the recipient receives on SSI. These are the types of things. But there are other things that don't count. And let's just talk about that for a minute. So you might be able to pay for a cell phone. You might be able to pay for a computer. You might be able to pay for a vacation. You can do educational experiences for the person with special needs. There are a whole host of things that you can spend money that benefit the child that will not be considered in-kind support and maintenance. And so that's really where when we are talking about setting aside money that you want to leave for that child, we'll put that money in a trust, most likely, and that trust will detail or have some description of how what that money can be used for, right? And that's really intended to say it can be used for these things because these things will not impact the person's eligibility for SSI. And it'll also say what it can't be used for. And what it can't be used for is really intended to be this in-kind support and maintenance or direct payments to the child. So the trust will prohibit distributions to that child that is going to have some adverse impact on their eligibility for benefits or the amount of benefits that they receive on a monthly basis. So there is also a penalty for giving away assets if you receive them and try to just give them away real quick, or if you intend to apply and you want to give away your assets right before you apply for benefits. There's going to be a look back period for up to 36 months if the government finds out about it. And then if it is, it's going to take the amount of money that was given away and calculated period of ineligibility for SSI benefits. So that's why, again, just raising your attention to this or calling your attention to this, because, you might, if it should be reported, right? Beneficiaries have an obligation to report receipts of gifts, unearned income, those types of things to the government. They're obligated to do it. If the government does find out about it, if they fail to report, then there is going to be very likely a period of ineligibility. So that's the most important sort of takeaway from that. And here's something that can very easily happen, right? Eric receives SSI benefits. His mother, because she didn't know or understand the impact of leaving an inheritance or a gift to her child would have on his ability to continue collecting benefits, gives him $20,000. He receives he gets that entire amount. It's going to cause him to lose 29 months of his SSI benefits. So not only is that money then spent down, it could have, and you lose the SSI benefits, then Eric is going to have to reapply for those benefits. And maybe he's able to do that on his own, but maybe not. there's going to have to be somebody that might have to help him do that. So it has a really big impact on somebody for, a relatively modest amount of money. That money could have been set aside. Eric could have continued receiving his SSI benefits, and that money could have been made available to enhance his life and help him in his life in a way that would not impair his ability to continue collecting benefits. Benefits recipients, again, are under a legal obligation to notify the Social Security Administration of changed circumstances, meaning that they have income or assets, that they've received a gift, they have a job, they've received, whatever. This report really is supposed to be mailed to the Social Security Administration. If they don't do it, the government finds out about it, and oftentimes they have ways of doing that, then there's going to be an issue. So now that we have that sort of basis of knowledge in place, let's talk about some asset protection strategies. I'm going to talk about 3 today that you can use. So asset protection strategy number 1. This might seem to be a little bit unusual, but who takes care of you? You really have to be thinking about that. And who takes care of your child? This is really quite important. So who takes care of you? You can't take care of your child unless you have first taken care of yourself. Because if you haven't taken care of yourself, right, especially while you're alive, then your child is going to really be in jeopardy. So you really need to take care of yourself first and plan for a sudden health event or something else that renders you incapable or disabled during your lifetime such that you can't continue to help your child. So some things that I would encourage you to do is inventory your assets, inventory your digital assets. We have so many assets that are in cyberspace right now, so many accounts that have a username and a password to connect to them. Many of us have bank accounts that we don't even get paper statements anymore. Who knows about them if we don't get a paper statement? So you really need to write your inventory of assets down, and you would want to create some type of a log of usernames, passwords, so that if somebody needs to step into your shoes because of a disability, that they have the ability to do that. If you go to my website, in the trust and estate planning section, you'll see a section on digital assets, and you can download for free a digital asset inventory, and you can use that for regular assets too. But I encourage you to do this type of a thing. It's more important now than it's ever been. Perhaps you want to have a set of instructions for you, right? What kind of care do you want to receive? Where do you want to live? What are your bills? What does somebody need to know if they had to suddenly step into your life to help take care of your finances or you personally? Really just a good idea to put something pen to paper on that. You should have a financial power of attorney so that somebody has the legal authority to step into your shoes and manage your financial assets on your behalf if you're unable to do that for yourself. You should also have a healthcare power of attorney, again, so somebody can make healthcare decisions when you are temporarily unable to make medical decisions for yourself. So very important. You can't presume under the law, if you're married, that your spouse is going to be able to manage your assets or make healthcare decisions for you. There is no such presumption, especially as it relates to your finances. Your spouse, under the law, doesn't have legal authority to control your assets that are titled just to you in the event you become disabled. So it's really incumbent upon you to have that power attorney in place, because the law does not presume that you would want your spouse to have access and control of your assets. And believe you me, if you have a bank account in your own name and you're incapacitated and your spouse calls the bank's going to say, I'm sorry, I can't give you that information. I'm not permitted to do so. Very tightly regulated. Another great way to plan for this is to have a living trust in place. This is a trust document that you create while you're alive. You retitle your assets into the name of the trust so that in the event that you have an incapacity, in that trust, you've named a successor trustee, somebody who can control the assets that are in the trust very seamlessly in the event you become disabled or incapacitated. So I would say good financial power of attorney, healthcare power of attorney. Best, living trust is really the best way to do all of that, to plan for, take care of you. And then who takes care of your child, right? If you're the primary caregiver, you kind of know the drill. You don't need you to tell you what this child needs, what their schedule is, what medications they take, what their likes and dislikes are, what to do in the event they're reacting a certain way, things to avoid, all those little things that a parent knows about a child. So you have to really take some time to write all of this stuff down. I'd start with, if your child has their own assets, you need, again, to inventory those assets, log in information, whatever it is that you need to control. Who is on your child care team? Who's going to care for that disabled child if you can't do it? You have to have somebody in mind, and they really have to agree to do it. So you have to talk with them about that and really have a fulsome discussion about what that means. Again, don't just presume that one of your child's siblings, one of your other kids is going to step in and do it or have the ability to do it, or maybe a friend. I've even had clients who have their hairdresser want to do it. It's when they start looking around, right? There are very, very few people who you would trust implicitly to care for your child. So it's a big, big thing to really be thinking about. Does whoever it is that's on your childcare team, if they needed to step in, do they have the legal authority to step in? That's really a key question. Could they access your child bank account? Could they make healthcare decisions for your child? You can't just say that they can do it. You have to put in place a mechanism by which they have a legal authority to make those decisions for your child and to help them out. So that's a really, really key item on that list. And again, they need those instructions for your child. All of those special things that a parent knows about their special needs child, you have to provide that information to somebody else. So ways that you can provide that person on your care team, that next in line to care for your child, the way that you can provide them with authority for the child. Of course, you could have a standby guardianship authorization. In Pennsylvania, if you have a minor child as a parent, whether they are special needs or not, you can have a document called a standby guardianship authorization by which you say, in the event of an emergency, if I'm disabled, I can nominate this person to step in to my shoes and serve as an emergency guardian for my child for it's 60 days. It can be extended beyond that. But that's a really important document to have if you have minor children. They don't have to be special needs. They can be any kind of a minor child at all, especially if you're a single parent. Very, very important document to have in place. And that'll certainly be influential on the court in the event you have a very long-term disability and a guardianship proceeding has to be filed. Now they're going to have something signed by you that says, this is the person that I trust to take care of my child. That's going to be pretty influential on the court's decision-making whenever they are looking around to figure out who can do it. Or in the event some other family member petitions to say, hey, make me the guardian, maybe that's not necessarily somebody that you would want or you would trust to do that for your child. Like I talked before, if you have an adult, maybe a power of attorney for an adult child that names as an alternative to you, maybe somebody else on your care team. So that would be something to get in place as well. Or a guardianship will have to be filed. Really, we would want to avoid that if at all possible, but sometimes it's unavoidable. But that might be the only other way that your care team, your second in command, your next in line, is going to be able to get legal authority to care for your child whenever you're not around. If you have a guardianship in place, you would want to take a look at the guardianship through the eyes of what happens if I can't be the guardian anymore. Is there a successor named? Is there some type of transition plan named in that document? If not, then you really should think about having some type of a succession added to that guardianship provision. And you certainly should seek out legal advice to talk about what your options are in that regard. Okay, asset protection strategy number 2, plan for the distribution of your assets at death. That's a lot of what we're talking about here today. So those resource limits, those income limits that we talked about, that your child every month has to comply with, right? It really makes it imperative that you've got an estate plan that does not pass assets to your kids who are eligible for these public benefits, because it's going to render them ineligible, right? All you're doing is giving up that very valuable government benefit and causing a lot of trauma and turmoil for your child. So again, your kids, children with special needs who are on those benefits, if they inherit assets, are going to be disqualified. And we just absolutely don't want to have that happen. Very important for you to understand, if you don't have a will, right, or some other type of estate plan in place, the government does have a will for you. And I don't think that you really want to rely upon that to care for anybody in your family, let alone a child with special needs. And there are a variety of reasons, one of which is trust in government is at an all-time low, right? I would never trust the government to take care of my family. The government's will for you and your family is called the law of intestate succession, or something close to that, depending on where you're dialing in from today. And those laws were typically written in the 19th century. And it's based upon definitions of the family that prevailed in the 19th century. And I think we can all agree that how we might define a family in 2023 is a whole lot different than a family would have been defined in 1880. It also, those laws have presumptions about how you would want your assets to pass whenever you die. And I think the presumptions in 1880 are probably a whole lot different than in 2023. And there are a lot of things that happen now that weren't even something that they could have figured out in 1880, like same-sex marriage, like in vitro fertilization, like the prevalence of divorce and stepchildren in lives. So these are all things that the government's will is probably not going to take into consideration. So it is your right as an American, right, to plan and take care of your family. You work hard for your money and you love your family. So it's really vitally important to make it a priority to take care of your family as a provider and get your estate planning in place, because really the government's will is not going to do a very good job of taking care of your family. Importantly, as a parent with a child with special needs, the government's will not account for your children that have special needs. It's going to pass assets to them in the same way that they were not a child with special needs. And so it can have a devastating impact on their ability to continue to collect assets. Second thing that's important to understand is that a will doesn't necessarily control all of your assets, where they go after you pass away. So a will does not control assets and accounts that are titled jointly. So if there are two names on an asset of some kind, like a bank account, like a deed, that asset is likely going to pass to the surviving person who's on that account whenever you pass away. So your will not impact that. If you have a joint bank account, that's the only asset that you have, and it has a child's name on it because you wanted your child to be able to write checks for you in the event you were incapacitated, and that's really the only reason that you put that child's name on that account. If you die and your will says divide my assets, which is my checking account, equally between my 3 kids, guess what? The will doesn't matter, because the bank account's gonna, the child that was on that bank account now owns all that money, and they don't have any obligation whatsoever to take a look at what your will says and comply with what your will says, because that account legally transfers ownership of that money to them whenever they die. So don't presume that your will, if you have one, is going to control those assets. Don't think that will is going to prevent that money from being distributed to your special needs child. The will not trump the titling of accounts. So very important to understand that. Assets controlled by a beneficiary form. So many of us have an IRA or a 401k, 403b, annuities, life insurance. All of these accounts have beneficiary forms attached to them. First and foremost, fill them out. Don't leave them blank. That would really be a bad situation. But don't necessarily say equally to my kids whenever I pass away, because that's what will happen. And if it goes to a special needs child, that child is going to be rendered ineligible to receive that benefit. And again, your will doesn't trump what your beneficiary form says. Your beneficiary form will be what is followed, and that's how that money will be distributed, regardless of what you have in your will. So just be aware of all of that. So some options, estate planning options for children with special needs. Of course, you can disinherit the child, right? You have to specifically state in your will, I disinherit my child. There are nice ways of doing that, believe me. You should also make sure that your child is not on any bank accounts, not a beneficiary on a beneficiary form of some kind. So you just want to make sure that you don't leave any money to that child. And so this is appropriate if a parent's estate is modest, right? And if the child's needs are great. Maybe it just doesn't make sense to include the child in your estate plan. And again, there are nice ways of saying that. Maybe a little bit uncomfortable of a thing to suggest to you, but it is an option that is appropriate in some instances. You may think that a good way to handle this is to simply leave assets to one of your other kids with an informal plan that child is going to manage those assets for your disabled child. Well, that plan, sometimes it works out, right? In families that get along well, that works out. There are very few of them. I will tell you, in my experience, a lot of families have turmoil of one kind or another. So I don't necessarily encourage this informal plan. And here are some additional reasons why you might want to think twice about doing that. You know, the sibling is really under no obligation to manage that money or spend that money on behalf of your disabled child. And that money might end up being misappropriated by that sibling or their spouse or some other person that has influence over them in their lives. That money could be exposed to that child's creditors if they've got bad credit or if they've got a judgment against them. Maybe they go through mortgage foreclosure, or they've got a debt collection agency chasing after them. You know, that money could be at risk and be taken, even though those debts don't really have anything to do with your disabled child who that money was set aside for. You know, that sibling who you've entrusted that money to might be going through a divorce. Well, their spouse, that money's just in an account in their name. And the spouse might take the position that's an asset that needs to be divided, you know, in the divorce. Might be a pretty difficult argument to make. There might just not be enough money to argue over there. So you don't want to have that happen. And then, of course, any income that is attributed to it for capital gains or whatever is going to be taxed to the sibling, and they may not want to have to pay the taxes on that, or they would take the money out of the account to pay the taxes. So it's really far from a perfect plan to do sort of a DIY, leave it to the sibling to take care of their brother or sister type of a plan. There are a lot of pitfalls to that kind of a thing. You really lose a lot of control. So what we suggest, really the best way to take care of this child with special needs, is to use some type of a special needs trust. So a trust, very basically, is a document that is created, and you have the settlor, or the grantor, that's you. You're the person who establishes it. And you're transferring assets, titling assets, into the name of the trust. So basically opening a bank account or an investment account in the name titled to the trust, the Jane Smith Trust, for example. And you name a trustee, meaning you've designated a person who is going to manage the money and follow the instructions that you have put in this trust document about managing and investing and spending that money on behalf of your child with special needs. That's what a trust is, in short. Trustees are what we call fiduciaries. They have an obligation under the law to act in the best interest of either the settlor, you, or the beneficiary. they can't take the money and spend it on themselves. They have an obligation to spend it for the best interest of whoever is entitled to that money, and that they're managing it for them. So that's very important obligation that you put them under, and it protects the interest of the beneficiary in the money as well. It really prohibits that trustee from engaging in any kind of funny business when it comes to managing that money. And a trustee can be anybody. It can be an adult family member. It can be a fiduciary like a bank or a trust company. It can even be a nonprofit organization. So there are no particular qualifications to serve as a trustee, although there are some things that they're going to have to do, and they can always hire professionals to file tax returns or prepare reports, things of that nature. But it can be anybody. It isn't limited to paying a bank to do that kind of a thing, although in some instances that's very appropriate. So let's talk about trusts. And for our purposes, there are basically two different trusts: living trusts and testamentary trusts. A living trust is literally sometimes called inter vivos. It's a trust that you create while you're alive, and you put money into it while you're alive. And it can be managed while you're alive as well. So you're actively managing it while you're alive, potentially while you're alive. A testamentary trust is a trust that you've put in your will, and it only gets funded after you die. The money from your will is paid into the trust and held there for the benefit of that child. That trust, or any of these trusts, can also be a beneficiary on a retirement account, an IRA, any type of a beneficiary form can designate the trust to receive the money that you are leaving on behalf of that special needs child. And I know I'm getting a little bit close in time. So trust can be both revocable and irrevocable, meaning a revocable trust is one that you create typically while you're alive. You fund it. You can terminate it if that's what you want. You have complete control of the assets that are in that trust while you're alive, right? It's your money. For all intents and purposes, you control that money the same way that you control your money now. It's just retitled in the name of the trust. There are irrevocable trusts as well, that once you create them, you can't get rid of them, can't terminate them, and you're going to have maybe some access to the money, but not a lot of access to the money. You won't be able to take it out and just spend it on yourself 9 times out of 10. There are other different types of trusts, and I think we don't really have to talk too much about these. We can certainly talk about them on a one-on-one if you would like to do that. But special needs trusts are a type of, or is language, sometimes called special needs trust, sometimes called supplemental needs trust. But anyway, what that refers to is a trust that you have set up to hold money and administer money for somebody that is special needs, that is eligible for these government benefits, that you don't want that money placed in that trust to render them ineligible. So you're going to place some special rules and restrictions on the management and use of that money. And those rules and restrictions will be set forth in the trust document, whether it's a living trust that you create while you're alive, or whether it's one that's prepared in your will that only gets funded after you pass away. So I know we're a little bit close on time, so I'm going to go ahead and see if I can answer a couple of questions here.